Ladies and gentlemen, welcome back to another legal breaking reporting and video analysis update. Federal Judge Immergut, who was appointed to the bench by Donald Trump himself, has dismissed claims that protests have hampered the conditions outside of the Portland ICE facility in southwest Portland. Let's get into that reporting and see what kind of bullshit that the Trump administration and his bullshit lawyers have told her.
A closer review of Oregon U.S. Judge Karin J. Immergut's 106-page opinion, permanently halting the federal deployment of National Guard troops to Portland, reveals how she tore apart the testimony of a key Trump administration official who was called as a witness and largely dismissed Federal Protective Service officials' complaints that Oregon's sanctuary law have hamstrung local police. Judge assessed credibility of witnesses. The judge determined that the testimony of Camilla Walmsley, the regional director of the U.S. Immigration and Customs Enforcement Seattle Field Office, was not credible. Immergut said she didn't find Walmsley's account of the damage done by protesters to the Portland ICE facility reliable, and she concluded that Walmsley's testimony claiming that protesters breached the ICE building on June 14th and had gotten into our lobby was not backed by any evidence. Walmsley testified that she visited the building in July to survey the damage, and she said all of the windows on the first floor and some on the second and third floors were broken. All the doors were broken and the steel gates were broken and inoperable. Immergut noted that there was no credible evidence. All the doors and windows of the ICE facility were broken. No other witness described damage to this degree, including Federal Protective Service Commander W.T. Will Turner, who was at the Portland ICE facility every other week the entire summer. Walmsley also testified that she did not know whether there were any photos of the damage or whether there was any documentation of the repair estimates, and her agency's internal records mentioned only one broken door and two broken windows prior to Walmsley's arrival at the ICE facility. The judge wrote, just as Immergut found Walmsley's characterization of the extent of damage to the building unreliable, she said she extends that finding to Director Walmsley's testimony on breach of the facility because it is inconsistent with every other piece of evidence received on the subject. The court therefore finds that protesters never breached the ICE facility. The judge wrote, testimony about injuries to officers also lacked corroborating photos or videos. The judge also noted, dismissed Fed's characterization of Portland police. Immergut, a former prosecutor who was elevated to the federal bench by Trump in 2019, pointed out that the federal officers and Portland police hotly contested the extent to which Portland police responded to criminal conduct outside the ICE building. The federal officers who testified argued that the Portland Police Bureau's adherence to Oregon's sanctuary law hamstrung their ability to execute law amid the nightly protests. Immergut wasn't convinced. The trial evidence demonstrated just the opposite, she wrote. While the federal officers testified that they would call Portland police to report problems outside the building and that they wouldn't respond, the judge gave more weight to the testimony of Portland police supervisors, including Commander Franz Schoening, Assistant Chief Craig Dobson, and Central Precinct Commander Brian Hughes. Immergut found that Schoening's demeanor and testimony at trial to be highly credible, and she said she afforded it great weight. The judge concluded that the police bureau established policies that allowed them to be a helpful partner in addressing crime that occurred at the protests, and sought to maintain an open line of communication with federal law enforcement and consistently responded to requests for assistance when resources permitted. While it was true that Portland police, concerned about violating Oregon sanctuary law, declined to help clear the street in front of the driveway of the ICE facility and would not clear debris protesters left in the driveway of the building, such an action by the Bureau was at most minimal interference with the execution of federal laws, the judge found. In a footnote, Immergut wrote that the occasional friction between the police bureau and federal officers due to Oregon's sanctuary law was a far cry from the civil rights era examples of deployment of the National Guard in response to state defiance of federal civil rights laws. She quoted Ninth U.S. Circuit of Appeals Judge Marcia S. Berzin in the California National Guard case, who described how former Presidents Dwight D. Eisenhower, John F. Kennedy and Lyndon B. Johnson federalized the Guard during the Civil Rights era when state law enforcement made clear they would not enforce federal orders and openly tried to prevent enforcement. Johnson federalized the Alabama National Guard to protect civil rights protesters marching from Selma to Montgomery from violent mobs. Kennedy federalized the Alabama National Guard after Governor George Wallace used the state's National Guard to prevent integration of public schools, again in violation of federal court orders mandating desegregation. Several years earlier, Eisenhower federalized the Arkansas National Guard and ordered them to stand down after the Arkansas governor had used the state National Guard to prevent desegregation following the landmark Brown v. Board of Education ruling. Although those deployments occurred under the Insurrection Act, the federalization of the National Guard was necessary to execute federal law, Berzin wrote. The Portland Police Bureau's failure to clear debris does not approach this level of obstruction, Immergut wrote in her ruling. Defined rebellion in evaluating the federal government's argument that there was a threat of rebellion in Portland. One of the criteria for Trump invoking the federal code's Title 10, Sec. 12,406 to mobilize the Guard, Immergut noted that what constitutes such a threat is not defined in the statute. She sought to determine its ordinary, contemporary, common meaning. At the time Congress enacted the statute, her ruling said. She concluded that a rebellion is something more than mere shows of discontent with law, policy, or government, and concluded that it's an organized group engaged in sustained, armed hostilities for the purpose of overtaking an instrumentality of government by unlawful or anti-democratic means. She cited as an example the Whiskey Rebellion, which was the single largest example of armed resistance to a law of the United States between the ratification of the Constitution and the Civil War. It occurred in opposition to a federal whiskey tax imposed in the wake of the Revolutionary War and caused violence in western Pennsylvania, making it impossible for excise officers to collect taxes. Then President George Washington called up the militia, equivalent to today's National Guard, when 7,000 to 15,000 armed men gathered to resist the law, her opinion said. She also mentioned Shays' Rebellion of 1786, when the governor of Massachusetts called in the militia to quell mob violence by about 15,000 armed farmers and Revolutionary War veterans who were upset at the state government's failure to provide debt relief. Founding-era presidents did not call forth the National Guard because the tax rebellions were violent protests against one federal law. They called forth the National Guard because the tax rebellions were sustained, organized, armed hostilities aimed at, and capable of overthrowing the new government, Immergut wrote. In stark contrast, the most significant violence outside Portland's ICE facility occurred on June 14th, when Portland police declared a riot. Unlike the historical rebellions where the president federalized the National Guard, local and federal law enforcement quelled the violence of mid-June, Immergut ruled. Immergut did not delve into the definition of regular forces, also part of Sec. 12,406 that Trump invoked to mobilize the Guard, contending he is unable with the regular forces to execute the laws of the United States. She said she's bound by the Ninth Circuit, which referred to regular forces as federal law enforcement, as the U.S. Justice Department has argued. In a parallel federal case in Illinois, a district judge in Chicago, she noted, provided a compelling reason why the phrase at the time of the law's adoption referred to soldiers and officers regularly enlisted in the military. Immergut said she did not need to resolve the dispute, noting it's now before the Supreme Court.
Well, ladies and gentlemen, with that being said, please like, comment, share, subscribe, and enjoy. This is going to be the third to last reporting for the evening of Monday, November 10, 2025. If you did enjoy this reporting and legal breaking analysis update, please like, comment, share, subscribe, and enjoy. And as always, I will look forward to talking to you guys in my next legal breaking analysis video reporting.